Because I didn't want to be in front of a trial judge who's just going to exercise their discretion potentially at a whim. Okay, next up, Hunter Brown versus Affinity Lifestyles. Let's go ahead and set forth our appearances for the record. We'll start first with the plaintiff, then we'll go to the defense.
Good morning, Your Honor. Eric Pepperman and Teddy Parker via Zoom for plaintiffs.
Morning, y'all.
Good morning.
Your Honor. Joel Odou in person and Eric Freeman via Zoom for AffinityLifestyles.com.
Morning, Your Honor. Jim Cavanaugh for the ETT1 DBA Terrible Herbs.
Okay, once again, good morning, and we had a status check regarding pretrial motions. Tell me, where are we at on that issue? I do realize they're getting filed.
Yes.
We did check that.
Yes.
We know that.
Yes, Your Honor. What we discussed last time we were in front of you was the court's availability for hearings on these motions on September 23rd, 24th, and 25th. That was before the court was scheduled to have its pre-trial conference on this stack. But our thought was if those days are still available for the hearings, we could schedule the hearings on those days and we should be able to get them all done in that time frame, if not less.
Yeah, I think there was one issue that came up. I was talking to Lynn. She's going to come in because I do know we have a trial that we have currently set. And which day were you talking about, Lynn? We might have a trial issue.
We start trial here and they may bleed into that day.
Yeah, there's one issue we might have that might impact the pretrial availability because we're starting a jury trial in the Wheelis versus Ramirez matter on September 16th. They promise 5 days, but you know how that can be. Just want to let you know that.
And we would know probably by the Thursday before where we're at. Right?
And so, yeah, we'll keep it, but if you get a call from us, say September 13th, that it looks like we need the 23rd, we'll let you know about that.
And what Tori and I just went over too, because we could start the Tuesday, Wednesday, and then the following week. And I've limited our calendars on October 1, 2, and 3. So we could possibly start at 10:30 on that Tuesday and Thursday.
Tuesday and Thursday.
Yeah, October 1 and 3. October 2 is business court day. So we can't guarantee a early morning start.
Yeah, and it may be that even if you bleed over to that Monday, the 23rd, 24th, and 25th will be sufficient. And if not, that we can.
We've got the whole next week blocked for you.
Sounds great.
The entire week.
I'm just not sure if 2 days, my colleagues have been in 3 of these together and they've got it down to a science. We're not as optimistic that we can get something like.
Well, that's why I'm not as
optimistic.
optimistic either. That's why we have, I think, 7 days set aside for it.
That would be more, I think, appropriate, assuming
Yeah,
all these have to be heard.
but the bottom line is if we need more time, we'll have it.
Okay, good. So it could be the whole week.
And the same thing, say if we still need October 7th. The jury questionnaire will say on or about October 7th for X number of weeks. So if their actual start date isn't until the 8th, then that can be done too. We've done that before. Okay.
Plaintiffs don't foresee that being an issue at all. Third
But
motions.
if it is, it is, and we got it covered.
Appreciate it.
That's kind of the best one. I mean, because Mr. Parker knows I always plan for the worst case scenario.
Absolutely. You definitely.
You know, because, you know, with, you know, I don't mind saying it. That's how I used to practice. I used to always look at it from this perspective. What is the worst thing can happen? And you can always, if you approach your practice that way, you never get in trouble, right? Because don't assume things will go according to plan. They never do.
Never do.
They never do. And that's why you always have to anticipate and dot your I's and cross your T's all the way through, right? And that way you stay out of trouble.
Good thing to do.
Because I didn't want to be in front of a trial judge who's just going to exercise their discretion potentially at a whim. We've all been there, right?
Indeed.
And it's not a good place to be. I understand that. So we try to stop that. We do. What else do we need to do?
One housekeeping matter. I did a quick count this morning. looks like we've got about 60 motions eliminating, about 6 to 7 motions for summary judgment. A lot of the issues this court has heard.
Oh, yeah, and did you get my little? Didn't we,
Yes, the order was filed yesterday for blind briefing for,
on that one issue, I filed a minute order because I thought about it. I really didn't, and remember the impact of my determination as it relates to summary judgment for the manufacturer, what impact it has on the distributor. I went back and thought about it, and here's the point. And what did I say here?
and then this was filed, yes.
It was filed yesterday. This is what I said here. I said, the court orders the parties to submit blind briefing for plaintiff's motion for summary judgment based upon the doctrine of issue preclusion within 10 days of the order posting regarding the impact of the court's finding pursuant to the restatement of torts 402A that the real water product was defective and a subsequent impact on retailers and distributors. And yeah, for failure to join, right? And I thought about it and I said, you know what? Two things. First and foremost, I think it's important to make a record as far as potential briefing, right? Just as important, maybe give me a little guidance. And last but not least, that's what I really would like to do. And that's why I ordered it, because at the end of the day, I have to make decisions, but I want to make sure I'm not making them in a vacuum. And I want your assistance in making those decisions. Make sense?
So we have 10 days from yesterday or
Yesterday.
today?
Yesterday.
I didn't see the order. We were.
Yeah, that's okay. That's why I brought it up. But my point is this, and I think we should have some vetting of the issue. And after I get the blind briefing and review it, if I need argument, I'll let you know. If I have concerns, I'll let you know. But it's really an important issue for your client.
Yeah, and I appreciate it. And I'm glad you pointed out for distributors and retailers. 'Cause
Oh,
they're not
absolutely.
distributors.
I understand the restatement of torts 402A. Right? And so that's why I did that, though, just so you know. I mean, there's a little method to my madness when I do things, right?
Appreciate
Yes, Your Honor, that's not a problem at all.
Yeah, because and potentially it could be a very important issue, and I just don't want to I never just do what I want to do. I always try to be tethered to case law and those types of things, and you know what I mean.
Just to clarify, blind briefing, Your Honor.
Just tell me, and I think it's a pretty simple minute order, but what I mean by that is give me some supplemental briefing on that specific issue. Because I'll say it again, because remember, that kind of came up out of nowhere. What impact does that have on the right here, the real water product was defective and a subsequent impact on retailers and distributors based upon the failure to file a joinder in opposition to plaintiff's motion for summary judgment based upon the doctrine of issue preclusion. Right?
Yeah.
It's pretty clear, right, gentlemen?
Yes, Your Honor, I know.
Thank
exactly.
you, Your Honor. Thank you.
Yes, and I mean, and the reason why I did that, I mean, this is a very important case for everyone involved. I get that. Just as important. I don't know if it's going to settle or not, but I don't want, put it this way. One thing I try to do, I try to take away appellate issues. I don't mind making decisions, but in a general sense, we don't have many appeals as it pertains to procedure. And the court failing to consider certain things, right? And that's kind of my point. I can get it right or wrong on the substance, but I'm not gonna have a case remanded back to me because of something I failed to do. Right?
Appreciate that.
Yes,
Yeah.
you do.
That's,
Appreciate it.
and so that saves you time and money for your client, you know.
Thank you so much, Your Honor.
That brings up the housekeeping question I was about to ask, which is, reply briefs are being filed on September 17th, I believe. It will take us some time to put together binders and get them down to the court. In addition, I anticipate the parties will be able to work out an agreement as to what motions should be heard together and when they could be heard together. Would it be all right if we get those to the court by, I don't know, Thursday is going to be tough. We could try. But last time it took the copy service 2 days to get everything copied and organized into neat binders for Judge Kishner, and I think it worked out well, but it just was a struggle to get them on time.
What, the hearings start when?
The hearing starts Monday, the 23rd. We anticipate the reply briefs will be filed, I guess the night of the 16th, so we get them on the 17th, because some filings occur after midnight for reasons that I don't need to explain. And then we got to get them printed and put into binders and delivered to this court.
What about the Thursday before? Is that fine? Where does that put us?
We just want to ink a date, Your Honor. We'll make it work.
Okay, or we can get it that Friday. Is it Friday before better?
It'll be Friday by noon, just so we have time to
Friday by noon.
organize everything.
By noon Friday. Okay.
How's that? That gives you a little
Thank you,
bit
Your
more time. And I will say this in a general sense, I don't anticipate many unique and new issues, probably a lot of the same, right?
There's a few, but there's not that many. I looked at the motions.
Okay. All right, that's what we'll do.
One other quick question, Your Honor. We know when the dates are. Does the court have an inclination of what order they're going to hear these matters in?
I was thinking the parties would hopefully agree.
If you agree, that's how I hear it. And you can send me a little agenda, a joint agenda, Judge, we want it heard in this order. And I don't mind telling you this, and this is typically what I do. If there's no agreement, I just go in order that they were filed.
Okay.
You know, that's the best I can do, you know, but if the parties agree, I hear them in whatever order you suggest.
And that was our understanding of the court's protocol.
Right. Yes, ma'am.
Which is
In
why
that agenda, can you include the docket numbers so we know which
Yeah.
documents you're talking about? Thank you.
And you notice with these voluminous documentations, even in our minute orders, we make references to the docket number. That makes it easier to find things, right?
No, Your Honor, we were actually discussing this week or two ago, that we understand how much easier it is with docket numbers, but they don't make it easy by printing the docket numbers on the documents.
Yeah.
I don't know if it's an internal system with the court or if that's possible to have the docket numbers on the documents with the file stamp, but
You know what
That's
you
been-
could do, I don't mind telling you this. Maybe that would be something appropriate for a bench bar discussion, because potentially they might have the capability for that. I don't know. But what we try to do is we try to make everyone's jobs easier as far as locating documents, because in a case like this, for example, you have so many motions, it might be very difficult to find. But if you had a docket number when it was filed, that helps.
I agree, it helps on our end too.
About half as many as last time. That's the good news.
Yeah. All
They're
right,
good ones, but they're good ones.
they're good ones.
All right, thank you.
Thank you, Your Honor.
Okay, enjoy your day, gentlemen.
Thank you very much. Appreciate it.
Thank you, Your Honor.